Yesterday, the ACLU and the Yale's Law School of Media Freedom and Information Clinic filed a motion with the Foreign Intelligence Surveillance Court seeking the release of secret court opinions that permit the government to acquire Americans' phone records en masse. This is dealing with the first disclosure, which was a court order, and we don't know for sure, but the suspicion is that it was simply a reauthorization of an ongoing program. In this instance, we saw the court order reauthorizing Verizon ordering Verizon to hand over all of these phone records. The speculation is, and I have not seen much pushing back against this, is that it's not just Verizon, it's all the phone carriers. And it's not just for this 3-month period, it's been ongoing, but it needs to be reauthorized every 3 months, which seems rather arbitrary at this point. Would it make a difference if it was 6 months? Would it make a difference if it was 9 months? Whether it was 60 days as opposed to 90 days? It doesn't seem to matter. That centers around, as we talked about with Marcy Wheeler last week, Section 215 of the Patriot Act, which allows the director of the FBI to obtain secret court orders from the FISA court, compelling third parties, that would be phone companies, and perhaps other entities that are involved in telecommunications, any tangible thing which is, quote, relevant to foreign intelligence or terrorism investigation. Now, the problem here is that relevant as a very broad term, tangible thing is a very broad term, and what the ACLU and this clinic from the Yale Law School are seeking is, what is the justification? What is in that black box? What is the function that you take that law, and what is the legal reasoning that comes out the other side? The real danger here, in my estimation, is this secret law, this regime of secret law. Because there is no oversight. When the Supreme Court rules on and interprets a law or interprets the Constitution, there is a very explicit mechanism for all of us to understand how they achieved that end result. We may disagree with it, we may not agree, we may agree with it, but it is part of a broader political process. We can then say, okay, I am going to exercise my agency as a citizen to agitate, to get my political representatives to change that law, or to amend the Constitution, or to elect a president who's going to appoint judges who have a different perspective on the Constitution. Those processes are are less than acute insofar as there's a lot of things that muck up that process, even beyond the fact that there may not be a majority of other voters or citizens who agree with that opinion that I may hold. Even once it goes through that process, it is degraded by money and influence, et cetera, et cetera. But at least that process exists. At least we can take measure of where we are as a society. This type of generation of law is incredibly problematic for democracy because there is no part in that process, as insignificant as it may be and feel at times. There is no part for us as citizens. And there is no oversight. There are no checks and balances to this. We also now know that this should give standing for any challenges of this program as there are millions of Americans who have reason to say the U.S. government is violating my Fourth Amendment rights. Of the literally hundreds of cases that emanated out of the warrantless wiretapping and the supposed warranted, although I don't know that you can call that a warrant by really any legitimate definition of the term. The idea that, I don't know that you can actually say it's a warrant if we just can pull everybody's records. It seems that there is an opportunity for this to be questioned. So, in a court of law, and this is just the beginning. This ACLU motion, or I guess motion to find out the legal reasoning behind this, is enough.